Hello viewers, in this lesson we will learn about the features and administration of the Foreign Exchange Management Act 1999. Objectives: to learn about the legislative history, features and basic structure of the Foreign Exchange Management Act 1999. To learn about the regulation and management of foreign exchange. To learn about the appeals and the appellate tribunal. To learn about Directorate of Enforcement and other related issues. This lesson explains the various issues relating to the Foreign Exchange Management Act, called in short FEMA. Viewers, now we will learn about the legislative history, features and basic structure of the Foreign Exchange Management Act 1999. Legislative history. For regulation and administration of foreign exchange in India, presently Foreign Exchange Management Act 1999 is in operation. Prior to this law, the Foreign Exchange Regulation Act 1973 was in force, by which the Foreign Exchange Regulation Act 1947 was repealed. The origin of foreign exchange regulation in India can be traced back to the Defence of India Act 1939 during Second World War. To preserve the foreign exchange in India, the then British government came out with many rules under the Defence of India Act 1939. After the Second World War, in the middle of 1940s, an acute scarcity of foreign exchange was experienced in India, and hence the Foreign Exchange Regulation Act 1947, called in short FERA, was introduced with an object to regulate certain payments dealing in foreign exchange and securities, and import and export of currency and bullion. India experienced certain anomalies and inadequacies in the operation of FERA, which led to its close review based on the recommendations of two reports, namely leakage of foreign exchange through invoice manipulations and trial and punishment of social and economic offences. And it was felt that the FERA has outlived its utility, even though several economists and financial experts observed that India was saved from the Southeast Asian currency crisis due to FERA. Taking into consideration the developments such as substantial increase in foreign exchange reserves, growth in foreign trade, rationalization of tariffs, current account convertibility and like ones, the Foreign Exchange Management Act 1999 was passed by the Parliament. It was brought into force with effect from 1st June 2000. Brief distinction between FERA and FEMA. Basically, in case of FERA, the approach to foreign exchange transactions was very conservative and restrictive, whereas in case of FEMA, the approach towards foreign exchange transactions is very positive and welcoming. Under FERA, the penalty provisions were very harsh, as imprisonment was imparted to the person violating the provisions, whereas under FEMA, only monetary penalty for violating its provisions is provided, and imprisonment is imparted only on non-payment of monetary penalty. The scope of FERA was very wide, as it dealt with all the transactions related to foreign exchange, whereas under FEMA, the scope is very narrow. FEMA deals with only specified transactions related to foreign exchange. It checks and controls only those transactions which are specifically mentioned in the Act. Important features of the FEMA. The FEMA is consistent with full current account convertibility and contains provisions for progressive liberalization of capital account transactions. It is very transparent in its application as it lays down the areas requiring specific permission of the Reserve Bank of India or the Government of India on acquisition, holding of foreign exchange. It classified the foreign exchange transactions in two categories, namely capital account and current account transactions. It provides power to the Reserve Bank of India for specifying, in consultation with the central government, the classes of capital account transactions and limits to which exchange is admissible for such transactions. It gives full freedom to a person resident in India who was earlier resident outside India to hold, own, transfer any foreign security, immobile property situated outside India and acquired when he was resident. Contraventions of the provisions of the Act entails arrest and imprisonment only in exceptional cases. The scope of the definition of resident in India is widened. Export of services is covered for the first time. Penalties are made severe. RBI retains powers to issue directions to the authorized person to secure compliance with the provisions of the Act, the rules, regulations, or directions thereof. The Appellate Board is replaced by the Appellate Tribunal. The powers of the Directorate of Enforcement are similar to those conferred on the income tax authorities under the Income Tax Act 1961. Presumption of culpable mental state is dropped, while presumption as to documents is retained. Offences committed under FERA deemed to have been done under the corresponding provisions of FEMA. Basic structure and scheme of the Act. This Act consists of 49 sections divided into 7 chapters. Chapter 1 contains the provisions on short title, applicability and definitions under sections 1 and 2. Chapter 2 contains provisions on regulation and management of foreign exchange under sections 3 to 9. Chapter 3 relates to authorized persons and powers of Reserve Bank of India under sections 10 to 12. Chapter 4 is on contravention of the provisions and penalties under sections 13 to 14. Chapter 5 contains the provisions on adjudication, on imposing penalties, and appeal to the Appellate Tribunal under sections 16 to 35. Chapter 6 deals with Directorate of Enforcement under sections 36 to 38. Chapter 7 contains the provisions on miscellaneous issues like rule-making power, savings, bar of legal proceedings, repeals, etc. under sections 39 to 49. Regulation and management of foreign exchange. The students must refer to the definitions under section 2 of the Act to understand some important terms like person, currency, securities, foreign security, person resident in India and resident outside India. Sections 3 to 9 of the Act contain the provisions on the regulation and management of foreign exchange. Under clause N to section 2 of FERA, the term foreign exchange has been defined to mean foreign currency and includes deposits, credits, balance payable in foreign currency, drafts, travelers' checks, letters of credits, bills of exchange, expressed or drawn in Indian currency, but payable in any foreign currency. Any draft traveler's checks, letters of credit, or bills of exchange drawn by banks, institutions, or persons outside India but payable in Indian currency has also been included in the definition of foreign exchange. Under clause M2, section 2 of the Act, foreign currency means any currency other than Indian currency. Section 3 of the Act prohibits any person other than an authorized person from dealing in or transferring any foreign exchange or foreign security to any person or making any payment to or for the credit of any person resident outside India in any manner or receiving otherwise through an authorized person any payment by order or on behalf of any person resident outside India in any manner except as provided in the Act, rules or regulations made thereunder or with the general or special permission of the Reserve Bank of India. Further, under clause D to section 3, any financial transaction in India as consideration for or in association with acquisition or creation or transfer of a right to acquire any asset outside India by any person is prohibited except as otherwise provided under the Act, rules or regulations. Clause C to section 2 defines an authorized person as an authorized dealer, money changer, offshore banking unit or any other person for the time being authorized under subsection 1 of section 10 to deal in foreign exchange or foreign securities. Clause O to section 2 defines the term foreign security to mean any security in the form of shares, stocks, bonds, debentures, or any other instruments denominated expressed in foreign currency and include securities expressed in foreign currency, but where redemption or any form of return such as interest or dividends is payable in Indian currency. For the purpose of this section 3, as provided under the explanation, financial transaction means making any payment to or for the credit of any person or receiving any payment for by order or on behalf of any person or drawing, issuing or negotiating any bill of exchange or promissory note or transferring any security or acknowledging any debt. Under section 4, no person resident in India shall acquire, hold, own, possess or transfer any foreign exchange, foreign security or any immovable property situated outside India except as provided under the Act. Section 5 imposes a restriction that any person may sell or draw foreign exchange to or from an authorized person if such sale or drawal is a current account transaction. The central government may, in consultation with the Reserve Bank of India, may impose any reasonable restrictions in this regard. Section 6 pertains to the provisions on capital account transactions. The Reserve Bank of India, in consultation with the central government, can specify any class or classes of capital account transaction which are permissible and impose the limits up to which the foreign exchange shall be admissible for such transactions. Further, it may prohibit, restrict or regulate several transactions involving foreign exchange and foreign security. However, the Reserve Bank of India shall not impose any such restrictions on the drawal of foreign exchange for payments due on account of amortization of loans or for depreciation of direct investments in the ordinary course of business. For details of the issues on which the RBI may impose restrictions and the exemption thereof, the students are advised to go through in detail the provisions under section 6 of the Act. This section also relates to FDI, that is foreign direct investments in India, which is governed by the FDI policy announced by the Government of India. The students are also advised to study the foreign exchange management, transfer of issue of security by a person resident outside India, Regulations 2000, and any other regulations issued or amended from time to time. The foreign direct investments can be made under two routes. One is automatic route, wherein the foreign investor or the Indian company does not require any approval from the Reserve Bank of India or the Government of India. The second one is the government route, wherein prior approval of the Government of India, Ministry of Finance, Foreign Investment Promotion Board FIPB is required. Section 7 relates to export of goods and services, wherein the Reserve Bank is the authority to regulate. Section 8 relates to realization and repatriation of foreign exchange. Section 9 deals with exemption from realization and repatriation subject to such conditions as are stipulated thereon. Contravention and penalties. Under Section 10 of the Act, the Reserve Bank is empowered to scrutinize the applications of persons and authorize any person to be known as authorized person to deal in foreign exchange or in foreign securities as an authorized dealer, money changer, or offshore banking unit, or in any other manner as it deems fit. Section 11 empowers the Reserve Bank to issue directions to the authorized person. Under Section 12, the Reserve Bank has powers to inspect the authorized person. Any contravention of the provisions of the Act or any rule, regulations, notification, direction, or order issued in exercise of the powers under this Act, or any contravention of any condition subject to which an authorization is issued by the Reserve Bank by any person entails the imposition of penalties under Section 13 of the Act. For any such contravention, the person responsible shall be liable to a penalty up to thrice the sum involved in such contravention, where such amount is quantifiable, or up to 2 lakh rupees, where the amount is not quantifiable, and where such contravention is a continuing one, further penalty which may extend to 5,000 rupees for every day after the first day during which the contravention continues can be imposed. Further, any adjudicating authority, that is, an officer authorized under subsection 1 of section 16, adjudging any contravention can impose additional penalty by way of confiscation of the currency, security, or any other money or property in respect of which the contravention has taken place, and the foreign exchange holdings, if any, can be directed to be brought back into India or shall be retained outside India. Section 14 contains provisions for enforcement of the orders of the adjudicating authority. Under this provision, a fair notice and hearing of the person on the charges made is mandatory, and if any person fails to make full payment of the penalty imposed on him under Section 13, within a period of 90 days from the date on which the notice for payment of such penalty is served on him, he shall be liable to civil imprisonment. A detailed procedure for notice, hearing, and arrest is laid under Section 14. Section 15 empowers the Directorate of Enforcement or such other officers of the Directorate or the officers of the Reserve Bank as may be authorized by the central government to compound the contravention on an application made by the person committing such contravention. Viewers, we will now learn about the appeals and the appellate tribunal. Section 16 empowers the central government to appoint the adjudicating authority to adjudge any contraventions by a person stated afore and to impose penalties. Section 17 contains the provisions on appeals to special director appeals. The central government is empowered to appoint one or more special directors' appeals to hear appeals against the orders of the adjudicating authorities and the matter and places in relation to whom the special director appeals may exercise jurisdiction shall also be notified by the central government. Any person aggrieved by an order made by the adjudicating authority, being an assistant director of enforcement or a deputy director of enforcement, may prefer an appeal to the special director appeals within 45 days from the date of receipt of the copy of the order made by the adjudicating authority. The special director appeals may entertain an appeal after the expiry of the set period of 45 days if he is satisfied that there was sufficient cause for not filing it on time. A detailed procedure for filing and hearing of the appeal is stipulated under this section 17. Appellate Tribunal. Sections 18 to 35 contain the provisions on the Appellate Tribunal. Section 18 provides for establishment of an Appellate Tribunal for foreign exchange to hear certain appeals. Under Section 19, any person or the central government aggrieved by an order of the adjudicating authority other than those referred to in subsection 1 of Section 17 or the special director appeals may prefer an appeal to the Appellate Tribunal within a period of 45 days from the date of receipt of the order of the adjudicating authority or the special director appeals. The tribunal can condone the delay, if any, at its discretion. The tribunal must deal with the appeal as expeditiously as possible, preferably within 180 days from the date of filing. The tribunal must give fair hearing or notice. The tribunal consists of a chairperson and such number of members as may be prescribed, and it can have benches at different places even though the principal bench is at New Delhi. The detailed procedure before the Appellate Tribunal and the special director appeals is narrated under Section 28 of the Act. Section 34 bars civil courts to exercise any jurisdiction to entertain any suit or proceeding in respect of any matter which an adjudicating authority or the Appellate Tribunal or the special director appeals is empowered by or under this Act to determine. Under Section 35, any person aggrieved by the decision or the order of the Appellate Tribunal may file an appeal in the High Court within 60 days from the date of communication of the decision or order of the Appellate Tribunal on any question of law. The High Court may condone the delay in filing the appeal, if any, but up to a maximum of 60 days further. Viewers, we will now learn about Directorate of Enforcement and other related issues. Section 36 of the Act provides for establishing a Directorate of Enforcement with a director and such other officers as the central government may think fit to take up investigation on the contraventions referred to in Section 13. Sections 36 to 38 contain the relevant provisions in this regard. Sections 39 to 49 contain various miscellaneous provisions. Section 46 contains the powers to make rules by the central government only, and Section 47 empowers the Reserve Bank to make regulations. Section 49 pertains to repeals and savings. All persons dealing with securities and investments in India from a foreign country or in a foreign country from India must necessarily follow the provisions of this legislation, and failing which they will attract the penal provisions. Viewers, I hope you have enjoyed this lesson. We will meet again. Thank you.